Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the Phia Group.
Hi, everybody. Welcome to another Empowering Plans podcast with the Phia Group. This is not a regularly scheduled podcast. If I sound a little sleepy, it's because I'm still rubbing my eyes and trying to get out of bed. Brady jumped on the phone. He called me. He called Jen. He said, guys, we've got to do a podcast ASAP about this Dobbs v. Jackson Women's Health case. A lot of people are referring to it as the Roe case or the Roe v. Wade case. You know, it's interesting that the case is referred to more frequently by the name of the previous case it's overturning rather than the name of the case itself. And so that tells you a lot about this and a lot about its ripple effect. Very few people referring to it as the Dobbs case, many more people referring to it as the Roe case. But yes, indeed, if you are tuning into this podcast, I am certain that you are aware of what's going on. It's impossible not to be aware of what's going on. You know, we've got myself, Ron Peck. I am the Chief Legal Officer of the Phia Group. With me today, I've got the Senior Vice President of our Phia Group consulting team, Jen McCormick, and also, of course, Brady Bizarro. I want to call him the Director of Legal Compliance and Regulatory Affairs, but, you know, he's more than that. He's the man on the street. He's keeping track of all these big cases that are coming out, political and otherwise. And so this one falls right in the middle of his wheelhouse. I mean, this is a combination of both political news and legal news and regulatory and compliance news. So Brady, this is your time to shine. You know, today we're going to try and talk a little bit about the case itself and what it means, not just itself, but also, like I said, the trickle-down effect, how it's going to impact health benefit plans, you, our clients, or those who service health benefit plans, employers. Recognize that different employers are going to react differently. Everybody's going to want to do something a little different. So there is no canned answer or canned solution. You know, one employer may be in a state where abortion is now illegal and they want to cover the cost of abortion and want to cover the cost of traveling to a state where it is allowed, where it's legal. Whereas another employer may be willing to pay for an abortion, but doesn't want to pay for the costs to travel. Another employer may not want to cover it. Basically, they're saying it's illegal in the state, so I'm not covering it. I'm a plan in this state. And what are their rights and responsibilities insofar as it relates to employees who reside outside that state and live in a state where it is legal? Are you required to cover it because where they're receiving it, it is legal? And so many other sort of derivatives and combinations. So there is no one size fits all. But, you know, again, and we'll get into this, there are so many different rules and laws in the various states of this United States of America. And often a plan, you know, needs to comply with one state law and not another. Of course, issues of ERISA preemption pop up. But until every state in the United States has exactly the same laws in every state, this is not going to be new. You know, it's new for this particular area, this particular subject, abortion. But there are other things. You know, one example, and I'll give you a quick one, just to kind of focus in, you know, we have plans that exclude claims arising from an illegal act, you know, or a felony rather. You know, in some states, driving under the influence of alcohol may be a felony, and in another state, it's a misdemeanor. And if you're excluding felonies and not misdemeanors, you know, where that plan member is driving under the influence, where they're injured, where they're in an accident, where the claims arise, is going to have an effect on how the plan applies its plan provisions and what's covered and what's excluded. So is it complex? Is it sophisticated? Is it complicated? You bet. And before we jump into the details, and guys, I hope you'll indulge me for one more minute, Brady and Jen, you know, whether I'm talking about abortion or I'm talking about driving under the influence of alcohol or really any other law, you know, so many laws that apply to us as citizens of the United States of America and as plan administrators who are administering health benefit plans for our employees. These laws, these rules, these regulations, they come from the state level, the state, okay? It's the United States of America. And one of the things that I think I discovered with not so much the Dobbs case, but rather the fallout, sort of the discussion, the national conversation that's come sort of out as a result of the case. So many people, I think, rely on the federal government to enforce the will of the people. You know, there's this belief or this concept that because the majority of Americans feel one way or another, that the law of the land, federal law, is going to reflect the will or the desire of the American population in general. But for anybody who has been through a presidential election where the popular vote is for one candidate and yet the other candidate ends up winning the office, it happens every 4 years where, you know, people scratch their head and say, now, wait a second, how could it be that Hillary Clinton, more people in this country voted for Hillary Clinton, and yet Donald Trump is president? People were shocked. They didn't understand. They still don't understand the way the electoral colleges work. They still don't understand the way the Senate and Congress works. They don't understand the amount of influence and power individual states have as it relates to our government. And people still don't necessarily understand that just because the majority of Americans feel one way, that's not necessarily what the law is going to say. Every state in the United States of America has a say, even if they're a low population state. And in the case of Dobbs, this is a situation where the Supreme Court basically said that they don't believe this is a right under the Constitution, and thus it's something that gets kicked back to the states. And if every state wanted to legalize abortion, they could. And I think that this really shines a light on the fact that people need to pay more attention to the local and state government and local and state elections. Because for people who only focus on federal law and federal elections, you know, this is a rude awakening. This tells you, hey, look, you really need to pay attention to what's going on at the state level, because so much power does get handed back down to those state government and the state lawmakers. So with that as sort of the foundation, sort of the opening sort of barrage, let's talk a little bit about what this actual case means in general and what it means specifically for the health benefit plans that we service. So Brady, let's go ahead and start with you. If you want to talk a little bit about the case itself, some of the things that we've seen sort of shaking out from it and sort of political, legal, what we're seeing from it. And then if we want to then transition Jen, we could talk a little bit about some of the work we're doing on behalf of the health benefit plans we service and some of the ways that we can help people adjust and continue to move forward in light of the new rules. Brady?
Thanks, Ron. Yeah, I think it's helpful at this point. I mean, obviously, we don't want to spend an hour, although I want to, going into the legal analysis of all the parts of this case. But I do think it's very important to do some of that here because, as Ron's been talking about throughout the introduction here, about how historic this case is, the implications it has. This is not something we see every day from the Supreme Court. They overturned a case, 50 years of precedent. It doesn't happen every day. And if you're watching the news and not living under a rock, you know this case is a huge deal. So really quickly, I just want to talk about why this case was overruled by the majority. You had a 200-page opinion, a 60-page dissent. You have multiple concurring opinions by other justices of the court. The dissent quite unusually signed the dissent as 3 people altogether, which is pretty rare to see happen. But essentially, what the majority found was that the Constitution does not include a right to abortion. That's the simplest way to put this. But that has extremely far-reaching consequences and impact because the original case, Roe v. Wade from 1973, of course, established what's known as a right to privacy, which is not explicitly in the Constitution, but nonetheless, that court, as well as many other rights that they considered at different times in the decades, like interracial marriage, the right to contraception, gay rights, they've enshrined those rights in this right to privacy, which they said, and the court has said for 50 years, is implicitly found within the 14th Amendment. The majority of this court disagreed with that analysis. And so by finding that there's no explicit right to privacy in the Constitution and therefore overturning Roe, that's sort of the legal basis for how we got to where we're at right now. The court takes pains, the majority takes pains, and so do some individual justices like Justice Kavanaugh to say that none of those other rights I just mentioned are meant to be under the microscope at this point, but the abortion right in particular has to fall because of this right to privacy, as they say, not being explicitly found within the Constitution. So what does it mean to have Roe overturned for the majority? It means that it returns the question back, like Ron had said, back to the individual states. Justice Kavanaugh, quite importantly, in his concurring opinion, made some points about to address some questions that will come up. One question was, what about women retroactively be held liable for having abortions in other states? The answer to that, he says, is no. What about the ability of people to travel to other states to obtain abortions? Justice Kavanaugh also says that he believes that would be unconstitutional because of the constitutional right you have to interstate travel and so on. But the dissent disagrees, obviously, with the majority opinion in this case, and they essentially say that the right to privacy is implicit, should have been protected. And so where do we go from here? And what we've been doing at Phia is crafting a response, both through plan language changes and just preparing some general consulting responses, because as you might imagine, we're getting tons of questions from clients in various states which have these so-called trigger laws, right, which are outlawing abortion in some cases right away, in some cases in a few weeks or a few months. And so we're trying to respond quickly to all those things. But I think at this point, with that sort of background of the case at a high level, I want to turn it over to Jen to talk about sort of how we've responded or what we think you need to change in your plan document as an example to make sure that you're in compliance or getting ahead of the changing laws that are coming out in this area. So Jen?
Yeah, thanks, Brady. And I appreciate the legal analysis background on this because there are lots of considerations when it comes to this particular case, and what you do and how you do it. It's going to depend on what hat you're currently wearing. So we have to take a peek at this from a plan administration perspective, but also an employer perspective. And I think it's easiest for us to start with the plan perspective. It's a little bit clearer about what we need to do, the questions that we might need to ask. And in preparing for our clients and making sure that we understand the scope of this case, the impact that this is going to have, the first consideration is what kind of plan you have. Are we looking at a fully insured plan? Are we looking at a self-funded plan? Because the type of plan that we're working with is really going to have an impact on what exactly we need to do here. So the fully insured aspect, let's put that aside and really focus in on having a self-funded plan. And when we're looking at our own materials, our own provisions that we have within our plan, we started to try and figure out specifically what provisions, knowing all that we do at this point, will need to change. And of course, this isn't to say that there won't be future litigation, because we fully expect that this is going to be an evolving situation. There's all kinds of case law and cases that we expect to see across the country and how this is going to play out, which means that there's the possibility, based on having a self-funded plan, that if you have participants in your plan that are located in multiple states, that the language that you're going to use is going to have a different impact based on where the different individuals are located. So we need to figure out a way for which to address that potential variation of the jurisdictional rules for that particular participant in our self-funded plan language, which is going to require a case-by-case analysis and review of the states and of the plan's provisions to make sure that you are doing that. So we have started this process by taking a look at the abortion provisional language. So you're going to have a lot of different variations for this because, as we just said, this is not a one-size-fits-all solution. So you need to customize this language, keeping in mind how you address the coverage or exclusion of abortion in line with what the perspective of the employer is, which we'll talk about in a second, versus what the rules are in that particular state for coverage, keeping in mind that maybe this is not a situation where you can outright exclude it or cover it, because this is not something that is based on the service itself, but the time at which the service would be permissible or legal under the state law, whether it's at 5 weeks or 15 weeks like we're hearing about in Florida. So those are the certain considerations when you're looking at this. First, what is the provisional language that you'll apply as it relates to abortion, whether it's coverage or exclusion? And when you're thinking through that, there are a lot of other federal laws that we need to keep in mind, like the Pregnancy Discrimination Act. What is the implication going to be for the Pregnancy Discrimination Act? What is the implication going to be for ACA? Is there a potential consideration for the extent to which abortion services, abortion drugs, whether it's a contraceptive versus abortion type of drug, is that a consideration in your plan? Is that something that you'll have to distinguish between the medical benefits and the prescription benefits? And the other thing for the plan provision that's important is we're hearing all about travel expenses. And whether or not we're going to allow, or our plan is going to allow the opportunity for the plan participants who are covered under the plan as a plan benefit, the opportunity to have reimbursement or up to a certain cap, similar to what we've seen for organ transplant benefits, to have the access to get reimbursed if you travel to another state where the services could be legal or would be considered legal, to have that. Will you be able to get reimbursed as an employer? And putting that language into the plan is also not a one size fits all, because there are certain considerations, potentially this being something, if you are narrowly putting the provisional benefits for the medical travel, could that be an issue? For example, with mental health parity, if you are allowing this specific to a medical service, is that a parity consideration? There are a lot of things that you'll need to review in the plan language when it comes to the implication of, but what we do know is that having the language in the plan and not reviewing it and not taking a look at it to make sure that you are not in compliance with the current state rules is a problem. This is something that must be addressed. You must review your language right now, make modifications or amendments to make sure that you are addressing this from the perspective of compliance for the plan, but also as the employer. And Brady, I can let you jump in too to share thoughts about how the impacts are going to be for an individual employer when it comes to the considerations they'll have to keep in mind about whether and to the extent that they're going to address this from a non-plan perspective.
Right. Yeah. I mean, that's a big unknown. And we've been working through this various state laws that are coming into effect. We're tracking them really all at once, because already as of today, we've seen some courts in these states like Florida, I believe also in Kentucky, block some of these state laws temporarily. I'm sure those laws will be allowed to go forward once, the highest court in the state reviewed the Supreme Court decision. But I mean, essentially, you're going to have to consider, what does the state law that you're in say? Does it criminalize abortion? Does it criminalize acts that aid and abet getting an abortion? Does it try and impose restrictions? Is there a viability line? Is there an exception for rape or incest, or the life of the mother being at stake, or the actual fetus being, damaged in some way? The Supreme Court case, remember, has effectively ruled that there's no need for limits anymore, except to the extent that there might be a conflict with the Pregnancy Discrimination Act, as Jen said. But you're really going to have to look at the state that you're in, or the state in which you have employees, to see what you should need to worry about as an employer, right, as far as allowing coverage for particular services in the state that you're in. And we expect, and Ron knows this too, there's going to be a lot more litigation here, right? Courts will be taking cases about, are reimbursing travel expenses. Is that considered aiding and abetting an abortion? What about states that have these so-called bounty laws, right, where anyone can bring a lawsuit against any person or entity who is, helping to facilitate an abortion? There's so many unknowns out there. And so that's why really a constant dialogue with professionals in this area is going to be required to make sure that your liability is being kept in check as much as it possibly could be, and that you're crafting policies and language that it covers all the eventualities that are possible out there.
So I think that as we look at this, guys, at the macro level, what lessons have we learned? We've learned that, I think a lot of people, myself included, sometimes take certain things for granted, right? We believe that because the majority of the population feels a certain way, that the federal government is going to implement that as law. But, we've learned, and as attorneys, we know this from education, that the federal government is really limited to whatever the laws say. And the role of the court is to interpret the law. And if you want something to be absolutely the letter of the law, then it needs to be written out explicitly by statute or in the Constitution. Otherwise, you leave it to the courts to interpret. And when they interpret, sometimes what that means is it gets kicked back to the states. So as benefit plan administrators or employers who are sponsoring a benefit plan, or entities that are servicing these benefit plans, you need to be familiar with and aware of two things. One, the state of the state law, but two, also the state philosophy, where if something that's currently regulated at the federal level were to suddenly be kicked back to the states, what do you think would be expected of you as an employer? What do you think would be expected of you as a plan? So that's all sort of that background legal education. More specifically, what we were just talking about is, as a plan sponsor, you need to identify two things. Number one, which laws apply to you. If you're a house of worship, if you're a traditional sort of fully insured carrier, if you're a municipal entity, school, fire, police, etc., state law is applying to you in a much broader sense. State insurance laws are applying to you. If you are a private self-funded plan, you're probably accustomed to this idea of federal preemption thanks to ERISA. But as we've discovered, certain state laws still apply. The state can't regulate you as an insurance carrier. They can't regulate you as insurance. However, other laws may apply. If you have an exclusion like the one I mentioned with the drunk driving incident, where you don't pay claims arising from an illegal act, the definition of what is an illegal act is based on that state's law. And so if you're in a state where abortion is considered to be an illegal act, that exclusion will likely have a role to play. So, to what Jen and Brady have been saying, and I don't think I can say this often enough or loud enough, is that it's not a matter of just putting language in your plan document that says we pay for abortions or we don't pay for abortions. You need to look at the entire plan at a global level because there are exclusions, there are provisions, there are terms in the plan document that did not apply to abortions previously, but now do, because those terms, those provisions apply to illegal acts in a general sense, illegal acts as defined by the state. And the states now, by virtue of this Dobbs case, have the ability to determine whether an abortion is an illegal act. And that's just one example. Travel is another thing. A lot of plans have exclusions for travel strictly for the purpose of seeking medical care. Who knows if there's some sort of network provisions? I mean, guys, we didn't really even jump into that too much, but who knows? Maybe you have a network that forbids you from allowing somebody to travel out of state when an in-network provider is available to provide treatment. I don't know. The point is there's so much interplay. This is not a one sort of amendment or one just fix it and forget it type scenario. This is going to require a full plan review. You need to understand which laws apply to the plan, and you need to understand what the plan's intent is so that we could then facilitate that intent at the global level from cover to cover. Guys, any other thoughts to share on this?
Boy, I just can't wait to keep watching how things unfold because literally as we're talking now, I'm seeing more alerts come up on my phone about, new cases, new challenges to various state laws and these temporary blockings going into effect. But I think, like it or not, this is going to proceed forward at the state level, and we'll keep watching really all 50 states as they react to this. Some states, of course, will protect a right to abortion services in their own state constitutions, like California is currently doing, and other states on the coast are considering. But then you'll have states that either have these trigger laws or are busily writing them right now. And it's going to be kind of the Wild West out there in terms of compliance and, just staying ahead of laws that are just popping into place left and right. But as always, we'll be doing that.
Speaking of the Wild West, and I don't want to forget this, I do feel as if we owe it to our listeners to mention this one important thing that we ourselves have realized recently. When you're on the internet, and it's amazing, I'm trying to teach my 6-year-old that everything online, just because it's on the internet doesn't mean it's true. The internet is a place where people voice their opinions as if they're facts. And for our listeners, it's important to take everything you read online with a grain of salt. I know I'm not telling you anything you don't already know, but there are many entities out there, including law firms, that you would consider to be objectively reliable that will post things or say things online that they may not necessarily say to a paying client. Even a law firm, when they post an article or a blog post or a podcast, remember it's part educational, but it's also part marketing and sales. And these firms, these entities, whomever it is that's publishing this material, they may have their own political leaning one way or the other, and that may flavor the direction that they take, number one. And number two, they know their audience. They know who their clients generally are, the population to whom they're trying to attract as prospective clients, and what their clients or prospective clients' political leanings would be. And so they may take a conscious effort to lean one way or the other to attract that target audience. So it may be a personal agenda, it may be to attract an audience, but either way, they may be taking a certain attitude, philosophy, or attack on a matter to specifically achieve a certain goal, rather than provide just sort of an objective, overarching analysis. The one thing I will tell you about the Phia group and about our efforts today and ongoing, both in this regard and other matters, is that we represent employers and health benefit plans from coast to coast, representing every philosophy. And our job is to try and help every single employer provide the maximum benefits possible to their employees for the minimum cost. And for some employers, that means one thing, and for other employers, it means something else. And we will not let any personal opinions or philosophies affect our ability to do the best possible job for you and to facilitate our clients' desires, whatever those desires are. And again, that's why we're taking a very objective, clean, analytical approach to this and not going to come out and say some extreme conclusions, again, like you can ignore it, or, oh, ERISA protects you from any anti-abortion law, even in the state where you reside. Again, I'm not going to go out and say something extreme like that until we have adequate facts, precedent, and proof that that's the case. So I just wanted to get that little disclaimer out there, Brady and Jen.
Great.
All right. Well, if there's nothing else to say about this matter, and I think we've covered it all, right? There's nothing else to talk about. We can move on to the next thing. Just kidding. This is going to occupy a lot of our time for some time. If for nothing else, it keeps things interesting, doesn't it, guys? On behalf of myself, Brady, Jen, Pat, the man Santos, the Triple P, the Pat producer of podcasts, the Triple Threat, the man, the myth, the legend, Pat Santos, and the entirety of the Phia group. Thank you once again for listening to this very important special report podcast, the Empowering Plans podcast with the Phia group. Stay tuned. There'll be more to tell. Talk to you soon. Be well.